Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the Self-insurers in Australia podcast. I'm Alorna Strong, a partner at Hall & Wilcox, and I lead our national self-insurance practice. And I'm delighted to be your host for this new season. In this series, we've been talking about issues that matter most to self-insurers, things that come up in day-to-day claims management and how you can handle them more effectively. So whether you're joining us from the office, out for a walk, at the gym, or on your daily commute, thanks for joining us. Today, I am joined by Stephanie Driscoll from our Perth office, who's a partner there, and Ben Clark, a special counsel from our Adelaide office. Thank you both for joining.
Thanks for having me.
Hello. Thanks, Alorna.
Today, we're going to be exploring psychological injuries, what is compensable, and how to defend these types of claims. This is our final episode in this season, so I've actually left the best till last. So I might just jump straight in, Ben and Steph, and go through the scenario and then ask you a couple of questions. So Simon Taylor has been employed with Smart Utilities for over 18 months. Over the past 6 months, Simon's performance has declined significantly. Key issues include colleague complaints, customer complaints, missed deadlines, poor attendance, and frequent late arrivals. In response, Smart Utilities have put into place an informal and then a formal performance review. Firstly, Simon was issued a verbal warning, followed by a written warning when there was no improvement. The process has taken some time, as Simon has taken some time off work and has refused to attend some meetings. In October, unsurprisingly, Simon lodged a workers' compensation claim alleging bullying and harassment by his direct supervisor and team leader. The claim includes allegations of being singled out and micromanaged, as well as being unfairly treated. Attached to his claim form was a medical certificate from his general practitioner stating Simon is suffering from stress due to being bullied and harassed, and that he is currently unfit for work. So Steph, I might start with you first. In Western Australia, would a classification of stress be an injury in your jurisdiction? Is there a threshold for the lodging of a psychological injury claim?
Thanks, Alorna. I'm going to give you a lawyer's answer. The answer is maybe, but yes, there is.
Perfect.
A threshold.
We're done now.
So I'll
hand over to Ben now.
Sorry, in WA, you have to actually establish that you've suffered an injury within the meaning of Section 6 of the Act. And the definition of injury includes a disease where that disease is contracted in the course of the employment, or there's a recurrence, aggravation, or acceleration of the disease which is suffered in the course of employment. And so a disease includes mental ailments, whether they're of a sudden or gradual onset. So a mental ailment where the employment has been a significant contributing factor to the alleged contraction or recurrence, etc. So what the cases tell us is that the condition suffered or the symptoms suffered by the claimant have to actually be outside the bounds of normal mental functioning. So finding something stressful per se won't be enough to constitute an injury. A diagnosis of stress isn't going to be enough, and really it's going to be a matter for expert medical opinion. Ideally a psychiatrist, although a GP certificate can be enough, or evidence from a GP to satisfy an arbitrator in WA that the condition is outside the bounds of normal mental functioning. But obviously there's got to be that explanation and rationale around what the symptoms were, and it needs to be made pretty clear that it is beyond just finding something stressful, which is a normal human reaction to something stressful. It's got to be more than that.
So, Steph, you mentioned that you would have a GP certificate and also an independent medical examination. I think it was what you mentioned. Just to go into a little bit more detail there, in terms of working out whether or not stress is an injury, what sort of investigations would you complete or recommend a self-insurer complete?
To start with, in terms of assessing whether an injury is being suffered from a medical perspective, I would just be gathering as much medical history as I can. subject to the consent that's been provided by the worker. So realistically, I would be asking for a copy of his treating GP records. If there's treatment by a psychologist or a psychiatrist, I'd be seeking access to those records as well, with a view to gaining a complete clinical picture of what was happening in his life in the lead up to the performance management and thereafter, and then putting that to the doctor. Yeah,
okay. So you're trying to get a complete sort of psychological history before and during, and before he started work, even going back perhaps to a pre-existing history if there was one there, and looking into that.
Absolutely. And perhaps just trying to get an understanding of how long he'd been with the business. So that gives you a pretty good indicator as to whether or not this is a new condition which could have been caused by work. But those medical records are really important for a number of reasons, and most critically to figure out what really was going on with this chap, and to figure out if he's brought the problem to the workplace or the workplace has caused it.
Yeah, good point. Ben, I might head over to you now in South Australia. In your jurisdiction, would stress be an injury, or are you going to give me the answer maybe like Steph did?
I am going to give you a similar answer to Steph and say it does depend. And the reason why it does depend is it depends on the type of claim being advanced. If we're looking at the facts here, Simon's clearly alleging a pure mental harm condition, so a pure psychiatric injury. So the starting point for us is trying to determine whether or not it is that pure mental harm type claim, or is it actually a claim which is alleged to have arisen as a consequence of a physical injury. So if it's the latter, then we have seen situations where stress and the like can give rise to an entitlement to medical expenses arising from a mental condition or a mental harm type stress. But if it's a pure mental harm injury, we've got to look at the definitions and our legislation, which talk about the fact that in order for Simon to have a compensable claim, there needs to be this pure mental harm, and then pure mental harm is then subsequently defined again as being mental harm that is other than consequential mental harm. So that's the starting point for us. And I guess in short answer, it does unfortunately depend.
Okay. So do you think that you'd be in a better position to determine the compensability after you did some further investigations? And if so, what sort of investigations would you do in South Australia? I mean, we've just heard from Steph what she would do in terms of clinical records. I assume they're probably pretty similar to you, arrange an IME, but can you just touch on that for the listeners?
Yeah, absolutely. We're effectively doing much of the same and similar investigations, to be honest. Clinical records are a big starting point for us. We really want to determine and get a clear picture of a worker's clinical history immediately prior to the alleged workplace stressors, but also dating back as long as we can in relation to other non-work related stressors which might be relevant to an assessment or a diagnosis of a psychiatric injury. So there might be non-work related stressors such as family related and personal concerns, which ultimately then going to be relevant to the question of whether or not employment is the significant contributing cause, which is ultimately the next test for us in determining whether or not the claim is compensable.
Yeah, okay. Thank you. So I might also just ask you both, we seem to be dealing with quite a bit of a management action type scenario, and I know that a number of other states and territories do have these defences. Steph, I just will ask you first, is there any sort of defences available to smart utilities in relation to this claim for compensation lodged by Simon?
Yeah, look, in WA, your entitlement to compensation is guaranteed pretty much unless an exclusion applies, and that's because it's a no-fault system, unlike seeking to access common law damages. So the types of exclusions here which would apply would be firstly just attacking the factual foundation of the claim. So if it's alleging particular conduct on the part of the employer and that conduct's denied, then you attack that conduct. But really the most obvious defence to this claim would be that the injury, if one is established, wholly or predominantly arose due to administrative action, which is a complete defence to a claim for compensation in WA. He can turn around and say the employer's conduct in relation to that administrative action was harsh and unreasonable. Section 7 of our Act tells us that if an injury wholly or predominantly arises from administrative action, then it's not an injury from employment. And administrative action, we're given some guidance as to what that means. So it includes an appraisal of the worker's performance and disciplinary action. It also includes other things, but those two are relevant here, and anything done in connection with one of those actions. And really the idea behind the exclusion is to exclude from liability any claims which would traditionally be seen as employment claims rather than workers' compensation claims arising from employment issues.
Yeah, okay. So you've got to first obviously check the factual matrix that Simon has said is correct, and then you would look at what sort of defences, and you're saying there's a reasonable management action defence in WA. It's a wholly or predominantly, and as long as it's not unjust and unreasonable, I think you said, or harsh perhaps. Okay, in terms of then what sort of evidence you would need to defend that. Assume you'd arrange some people call it a factual investigation, some people call it a circumstances investigation. What would the next steps that you would take to work out whether or not Smart Utilities could avail themselves of any sort of reasonable management action type defence?
Well, I'd be really just honing in on what the real cause, so the whole or predominant cause, the real cause of this chap's condition. And so, as you say, that it would involve getting a factual investigation, and I'd be really trying to build a picture of him as a whole. I know that sounds funny, but I'd be trying to get a real picture of why his performance declined, what his job entailed and what he was doing, and whether everything that was being asked of him was reasonable. So I'd be looking at his work history, his job description, his performance history. I'd also then be assessing the employer's conduct in response. I'd be asking for the policies of the employer to just ensure that the action that they've taken is consistent with their policies, and also looking at whether there've been any complaints made by this particular worker or issues raised against this particular manager by other workers, to just assess whether there's any suggestion that the action that was taken was potentially not reasonable. So that's the type of evidence I'd be after, just trying to build that picture from an evidentiary perspective.
Excellent. Thanks, Steph. That was a really good answer and really thorough. Ben, just jumping into South Australia, is there a similar defence in your legislation? And if so, how does that work in this scenario?
Yes, there certainly is. In South Australia, we've got similar wording legislation to WA. We again use the wording wholly or predominantly. So there is a complete defence to a psychiatric injury claim where a claim is found to have arisen as a result of what we commonly term as exclusionary provisions. And those exclusionary provisions relate to circumstances where the injury has arisen wholly or predominantly from any action or decision designated under Section 7, subsection 4 of the Act. I won't go through each of the relevant subsections. There's 4 of them, but I will provide some examples. But again, similar to WA, they relate to circumstances where they're really focused in on employment-related factors. Whether or not the employer's made a decision to transfer, demote or discipline or counsel a worker and the like, whether there was reasonable administrative action, and importantly, that action needs to be taken in a reasonable manner. Similar to WA, where there's the harsh and unreasonable test, we've got a similar type of threshold where we often find it really difficult to either establish or gather evidence to prove that the conduct of the employer was undertaken reasonably and was undertaken in a reasonable manner. So for the purposes of trying to establish that kind of, threshold, the investigations that we often undertake, in addition to what Steph has mentioned, which include your factual investigations, but what I often try to hone in on is not only determining what are the workers' allegations and focusing on the employer's responses to those allegations, but really determining the way in which the employer conducted themselves in relation to any performance management related issues that may have arose, and really trying to get a bit of a timeline in terms of when did this particular worker's issues arise, what then transpired over the course of his or her employment journey, and then was there a straw that broke the camel's back, and are we able to determine what is the real cause of this incapacity. And often we then try to tie in the clinical records to determine, well, is there other non-work related stressors which are happening in the background, which we can try to determine, is this a work or employment related issue, or is this realistically a non-work related issue?
Yeah, and also not to undo that wholly or predominantly, I suppose the clinical records would tie in there to make sure that he was attending at the time that this performance management was being undertaken, and that's what was causing him his psychological condition. Okay, that's really great. Thank you both for that. I might just jump into the next scenario. So Monica Bing is a 34-year-old administrative officer. She's been with Friends Incorporated for nearly 5 years and has consistently received positive performance reviews. Her direct manager, Chandler, has overseen Monica's work for the past 3 months. Monica began to feel increasingly uncomfortable with Chandler's behaviour, which included compliments on her physical appearance and unwelcomed physical contact, such as placing a hand on her back or shoulder during conversations. Outside of work, text messages late at night, including compliments and questions about her personal life, and unsolicited social media interactions, including liking old photos and sending private messages, made Monica feel surveilled. Monica lodged a workers' compensation claim alleging sexual harassment and harassment against her manager, Chandler. She is diagnosed to suffer from an adjustment disorder with mixed anxiety and depression. So in this scenario, I was just interested, let's take it that she's established a diagnosable psychological injury and she's managed to meet that threshold. What I wanted to ask you both, and either of you can go first, is wondering, does it matter that some or most of the inappropriate conduct occurred outside of work hours?
I think the short answer is no. Again, we need to look at the wording of our legislation. Has it arisen out of or in the course of employment? Is employment the significant contributing cause? But when we're looking at the factors which would suggest that the claim is a compensable injury and that it doesn't matter that the alleged inappropriate contact occurred outside of work hours, the factors which I would suggest would be relevant would be the fact that they knew each other through work. This bloke was her direct line manager. He was in a bit of a position of power, and there might have been this perceived pressure to have to respond and engage, or at least in the conversation, so to speak. But what we really need to do is focus on the factual matrix. There actually has been a similar decision that's been handed down in the Employment Tribunal in South Australia back in 2021, where there were similar allegations of untoward conduct from a manager, but it was found that the complainant or the worker actively actually engaged in that lewd and sexualised workplace banter, which then undermined her allegations. So the tribunal ultimately found that her claim wasn't compensable because it was effectively she wasn't exposed to the inappropriate level of conduct that was being alleged.
Yeah, in this case, I suppose Chandler is touching her, so there is stuff occurring in the workplace, so there is confirmation of that, and it's arising out of or in the course of your employment, so during work hours, even though some of it is occurring outside of work hours. So it seems like there's a real connection there between what's happening to Monica and her workplace. Steph, similar in Perth? What happens there?
It really is. We've got a very similar test in terms of the alleged injury has to be contracted in the course of the employment, whether at or away from the place of employment. Employment needs to be a significant contributing factor, and similarly we've got the factors that need to be taken into account listed in Section 6 of the Act. I've had a few of these claims over the years. They're not all that uncommon, sadly, and there's always more to meet than meets the eye when you get one. I think in short the answer is it probably doesn't matter. If the account provided by Monica is borne out by the evidence, and the answer is no. I don't think it matters because they met in the workplace. The conduct commenced in the workplace. There's the power imbalance, which Ben's noted, between Chandler and Monica. He's her manager. She would be hard-pressed not to respond to contact away from the workplace because of that power imbalance. I think she would feel the impetus to respond, or that she was obliged to. And another factor which I've taken into account is that in matters I've had is that the employer could presumably take action in relation to Chandler's conduct in terms of his contact with her. So to me, that gives it an employment context, subject to all of the usual caveats. I don't think it matters that the conduct or that much of the conduct and contact has occurred outside of work hours.
Yeah, that's a good one. I think that's probably the first time that's been raised, the fact that Chandler's behaviour would be subject, arguably, to an investigation because it's inappropriate. That's a good point, Steph. What about if in this similar or same scenario, while you're investigating, for example, the claim for compensation, you undertake a factual or circumstances investigation, and during that Chandler provides a statement and he basically says, yeah, I put my hand on her back during work hours. There was nothing sexual to it. I was just trying to make Monica feel welcome, and that's all it was. Does that mean that because Chandler didn't mean any harm by Monica, is that a defence for the employer to say, oh, we can't accept this claim? What's your viewpoint, Steph, on that one?
Look, I'm in two minds about my answer to this, so probably no. Again, the employer might want to argue that the factual foundation of the claim isn't established because the conduct complained of isn't there. However, the defence is still going to very much depend on the objective evidence that supports either person's account of what happened. And if Monica can establish that she perceived that she was being harassed due to the nature and timing of that contact, I think there's a sufficient...
That's enough?
I think it'll be compensable, because the cases tell us that all she needs to show is that some or all of the incidents occurred in the manner alleged, and that the state of affairs that she alleges that actually existed. So that can be enough to establish liability. She doesn't have to prove that her subjective perception of those proven facts was reasonable.
So basically she just has to prove it happened, as long as it happened and it's not made up.
That she was harassed.
Okay. Ben, what about in South Australia? What would happen there?
Yeah, I think the answer would be no as well. At the end of the day, it's a no-fault jurisdiction. If this matter on these facts proceeded to the Employment Tribunal NSA, I think we'd be finding ourselves in a position where, based on that perception argument, the court will look at how Monica interpreted the events that transpired, not from the perspective of an objective layperson or from Chandler's point of view. I think it will be found to be a compensable claim, but again, we do need to take a close look and examination of the facts to determine whether or not Monica's perception was based on reasonable terms or reasonable grounds and wasn't completely fabricated, for example. And if that was the case, then that would be a defence to the claim.
Yeah, okay, excellent. Now, I've done this to all of my people that I've been asking these questions to. So how about we change the fact scenario just slightly, and on the basis that Monica and Chandler were in a relationship and that it recently ended, and following the ending of that relationship, Monica decided to lodge that claim for compensation. What do you think would happen in that scenario? Would that claim be compensable? Does the fact that they're in a relationship matter, or does it depend? I'll hand over to you, Steph.
Oh, geez. I think there's two potential factual scenarios here. One is if she claimed that it was due to harassment and it turns out and it transpires that it was a consensual relationship, then I'd be saying, the factual foundation of your claim is not going to be borne out and the evidence can't be relied on. If it's a complete switch in the facts and she lodges a claim on the basis that she was having a relationship with her manager which came to an end, I would probably try and argue that the employment connection is a bit tenuous and what you're really dealing with is a condition which arose due to personal matters of a private nature, and therefore there's not a sufficient nexus between those matters and the employment. Again, because of the power imbalance, I think it could still be compensable. All she would need to show is that she felt that she had to be in a relationship or she felt uncertain about ending it or something like that. I think because of that power imbalance, and I think that may make it compensable.
It really depends on the factual matrix.
It really does.
And then how she frames it.
Absolutely, and I'd be looking very hard at the timeline of what occurred between them. Okay.
Ben, what about in South Australia?
Yeah, from an SA point of view, it's just as difficult to assess. I would probably approach it in a very similar way to how Steph has, but from an investigative point of view, I would probably start with trying to again look at the clinical records to determine when any stressors arose in
Good one.
conjunction with any employment related complaints and the nature of those complaints. A factual investigation might determine if she's complained of her stressors to colleagues or to management and the like, or to other managers and the like. And that might assist in determining what the nature of those complaints are, the timing of those complaints, to then really have a closer look at, is this an employment related injury or is this a completely non-employment related injury? So I think we really need to tease out, is this a consensual relationship that's gone wrong, or is this sort of a bit bigger than that?
Yeah, okay. It seems like in both factual scenarios, the really key crux of all of it always comes down to the facts, I think, and he said, she said it, and making sure you do your thorough investigation, factual investigation, and get to the bottom of what's the timeline, what's the factual matrix, were there any witnesses, what happened in both scenarios, I think, and then also looking at the clinical material to see whether or not there are any pre-existing conditions, what the worker actually complained is a cause of their current symptomology, and then perhaps looking at an independent medical examination just to round that all out. Just wanted to say thank you both so much for your time. That was really great. I hope the listeners got a lot out of that. I surely did. This is our last episode, which is sad in this series, but I'm sure we'll be back again with another topic and another series. So I just wanted to thank you both. Thank you so much for your time. It's much appreciated. And thank you to everyone for tuning in. If you have any questions or want to chat more about anything we've covered, please feel free to get in touch with us. Our details are hallandwilcox.com.au, or you can connect with us on LinkedIn. If you like today's episode, please rate, review or subscribe wherever you get your podcasts, and we'll catch you with our next series next time. Thanks, Steph. Thanks, Ben.
Thank you both.
Thanks, Alana. Thanks, Ben.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.